Hello friends, I'm Dr.Aftab. I'm going to share my experience with regard to disciplinary proceedings that I have been dealing with for the last 6 to 7 years. I've just tried to encapsulate my experience in few bullet points that will give an idea that how we can take care of disciplinary proceedings, because it is very much important to follow the procedures of disciplinary matter, and if we fail to observe the entire proceedings, by virtue of that we pass an order on a delinquent employee which is vitiated in a legal court, and the management has to bear a lot of implications in terms of money, time and resources. So it is very important to understand disciplinary proceedings. So for my understanding and for easy understanding as well, I have categorized the disciplinary proceedings into three main stages, or three stages you can say. The first is pre-stage, second one is main stage, and the last is the concluding stage. The pre-stage of disciplinary proceeding is it starts as soon as any misconduct takes place and it is reported to the concerned official, or you can say the head of the department. That concerned official or the officer in charge takes it into cognizance and does the preliminary investigations, collects evidences and witnesses, and it is analyzed whether the misconduct is grave or not. And if it is final and decided that the gravity of the misconduct is as such that the doer or the delinquent employee is to be penalized with reference to the code of conduct, then we look for an authority who can impose this penalty. Meaning by that we have to, the management or the organization has to appoint a competent person, that is disciplinary authority, to impose that penalty. Who can be disciplinary authority? Disciplinary authority can be one level above the delinquent employee. Who can be the disciplinary authority, and which is appointed by the organization, you can say the competent person in the organization. The disciplinary authority has to initiate the disciplinary matter by issuing charge sheet. Disciplinary authority issues this charge sheet to the delinquent employee. Here I want to mention that issuing charge sheet is very important act, that as soon as the charge sheet is issued, the main stage of the disciplinary proceedings start. And charge sheet is a very crucial document which needs to be drafted with great diligence, which is to be drafted with reference to the actual the misconducts, the charges and the rules of the code of conduct, and in view of the evidences and the witnesses. That charge sheet will be served against the delinquent employee, and the disciplinary authority will seek reply from the charged official within a specified period of time. Here, a disciplinary authority has to give sufficient opportunity to the charged official to submit his or her reply. After the reply is submitted by the charged official, the disciplinary authority has to move ahead accordingly. If charges are accepted by the delinquent employee, then the order will be issued accordingly. Or if the delinquent employee pleads not guilty, then the disciplinary authority will initiate inquiry. Why to initiate inquiry? Because Article 311 of the Indian Constitution says that nobody can be punished before an inquiry in which his charges and allegations are proved with the evidences and the witnesses adduced during inquiry. So, before an inquiry, nobody can be punished. So, it is very important to initiate an inquiry. The disciplinary authority will appoint an inquiry officer to initiate inquiry or to conduct the investigations. Inquiry officer can be from the inside organization, or he can be from outside, any experienced officer, you can say the legal expert, or the person who has dealt various cases of similar nature can be appointed as inquiry officer. Inquiry officer is quasi-judicial in nature. Therefore, he has to listen to delinquent employee and has to give sufficient opportunity to the person of being heard. And therefore, the inquiry officer has to conduct the trial in fair manner. This ensuring there are various principles of natural justice, right to fair trial, that all people are equal before eyes of law, nobody can be punished twice for the same crime, etc., are the principles of natural justice, which prevail in human society since time immemorial. And all these principles of natural justice have been enshrined very much in our Indian Constitution in Article 311, specifically in Para 1 and 2. Therefore, this inquiry officer has to take care of all these things. After listening to the delinquent employee or the charged official, the prosecution and cross-examination, the inquiry officer will submit a report to the disciplinary authority, and disciplinary authority will review that order, and if he agrees, he can go accordingly. If he disagrees, disciplinary authority can remand back the report to IO for review. And when that report is submitted again to the disciplinary authority, the disciplinary authority will seek a final reply from the delinquent employee against that report by the inquiry officer. And after taking that final plea or submission by the charged official, the disciplinary authority will go ahead and issue a penalty order. And that penalty order has to be a speaking order or a reasoned order, along with all, you can say, facts and figures and all documents and witnesses. Once that order is passed, in disciplinary proceeding, there is provision for review or appeal. The charged official can go for an appeal and can file his appeal before appellate authority, and appellate authority has to be notified prior by the competent person in the organization in that particular matter. Appellate authority will review the appeal and accept or reject. And then after the rejection of that appeal, that delinquent employee can go to the reviewing authority, who can be the highest, you can say, the most competent person in that particular organization. So this is the way that entire you can say the proceedings can be concluded, to ensure a fair trial, or so that we may not bear or face the adverse, you can say, implications in legal court. So I hope that it will give you an idea that how we can go for disciplinary proceedings. So thank you for hearing me and listening to me so much with so much patience. Thanks a lot.